Hold on, don't speak over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence to be sent.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement, because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is. It looks like you did a very good job of getting that agreement.
That's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history. The first page of his, or I guess, rolling into this second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000, all one, in January 2002. They all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case, he's
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that, and even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better, and he tells me he's ready to make that change, and he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can, oh no. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin. I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something, and I hope it don't hurt me, but I got to bring it up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. if I'm off of them, and the reason I got off of them and this offense happened is, I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. I'm sorry, 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting. I was losing, and I hit him. If you do give me the chance, what I need is some help staying on my meds. I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Yes, ma'am.
The problem is, you're 51 now, 52?
51, ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, this
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38
We're talking.
felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith?
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's
That was my
pending.
last one.
Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account to probation, where he said the part about the baseball bat is not true. A dresser fell on top of
I saw that.
it. He's still not accepting
I
responsibility.
hit him with
Legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not. And you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. Try again, same number. All right, let's see, Mr. Nichols, we're gonna try again on Christopher Norris.
Dorothy, can I help you?
Hi, this is Judge West. I'm calling.
Hello.
How are you, ma'am?
Good.
Good. You have Mr. Norris with you?
We have got him coming on his way right now.
Okay.
To retrieve him from class.
Okay. Just let me know as soon as he gets there.
Wonderful. Thank you, ma'am. I hope that's good. He is coming through the door right now.
Thank you.
Hold on one moment.
Hello?
Hi, Mr. Norris. This is Judge West.
Oh, okay. Is that you, Judge West?
It's me. How are you?
Okay. I'm doing good.
Good.
Doing fine. I'm just ready to go home.
Well, we're gonna go through what we've got today and figure out what we're gonna do. This is cause number 01. I think they put me on hold. Hello?
There we go. Woo. Technical issues.
Ma'am?
Technical issues for a moment.
That's okay. We had some nice music to listen to for a minute. All right, so this is cause number 0184078, and it's the state of Texas versus Christopher Stephen Norris. For the record, Mr. Rojas is here in the courtroom. Hold on a second. Can y'all please keep it down, sir? Mr. Rojas is here in the courtroom representing Mr. Norris, and Mr. Nichols is here representing the district attorney's office. Mr. Norris is charged with the offense of murder and was found not guilty by reason of insanity many years ago, and was ordered under 46C to inpatient treatment, and I have received the yearly report from the Rusk State Hospital where Mr. Norris is currently staying, and that report is dated May 12th of 2025. I'm going to take judicial notice of the court's file, including that report. The first part is the forensic evaluation of violence risk assessment. This was prepared, let's see, hold on just a second, let me get to the end, by Dr. Mary Ann Robinson, February 28th of 2025. The finding in that report with regard to future violence is that Mr. Norris needs to be still in some type of restrictive setting due to the current issues that have been exhibited over the last year. Talks about a potential less restrictive setting. However, he is in that less restrictive setting at the Rusk State Hospital, which houses the less violent patients. Also, in addition to that, I have the forensic psychiatry report to the court. This has information prepared by Dr. Calvin Gurka, and the recommendation is that Mr. Norris be recommitted to the Rusk State Hospital for further treatment towards the objective that he be able to transition to the community at some later date. In addition, I have received the physician's certificate of medical examination for mental illness, the first prepared by Dr. Gurke as well. The finding in that report is that Mr. Norris is mentally ill, that he is likely to cause serious harm to others and suffering severe and abnormal mental, emotional, or physical distress. There's some details in there regarding recent behavior and things like that. It makes the finding that current inpatient treatment is still warranted. Also, okay, so that's it. All right, and it's got some history also as well. Is there any other evidence with regard to this matter, Mr. Rojas?
No, Your Honor.
Mr. Nichols?
No, Your Honor, we just asked the court to take judicial notice of the entire file dating back to his original commitment in 1998.
Yes, I think I did, but if I didn't, I will do that. All right, so Mr. Norris, at this time, I am going to find, based on all of the reports, that Mr. Norris is mentally ill, that he is likely to cause serious harm to others, that he is suffering severe. Hang on.
That's not true.
Hang on, sir. That he's suffering severe and abnormal mental, emotional, or physical distress. I am going to find, based on all of those reports, that inpatient treatment is appropriate and order Mr. Norris to be remain at the Rusk State Hospital for a period of 1 year, and then we will see where things get. So, Mr. Norris.
Yes, I feel like we can do without my lawyer. He's not helping me none.
Well,
I feel that all these statements that the doctor's saying is not true. I mean, it's like he's picking something up on me every week. He's like, so he's got things on me. It's not one thing, it's another thing. You know, it's kind of hard to get out of here. I mean, I was in another board, and I mean, it's hard because there's a lot of fighting going on here. I mean, it's hard to make it a whole year, you know, and, you know, I try my best, but years is a long time to be around all these mental patients because they'll just run up and hit you, and they call that a fight. And they say you're aggressive. But I haven't been in no aggression fight, period.
well, there's other issues that concern me, Mr. Norris. We tried a couple of years ago, or it's probably been longer than that, where we tried a less restrictive facility, and I actually agreed to do that. That did not work, and I ended up having to have you put back in the Rusk State Hospital. So I am not comfortable with any release to a less restrictive environment based on what all of these reports say. My advice to you, Mr. Norris, is to participate in everything that is offered. Take your medication as ordered, and then we'll see where we get in a year. All right? Y'all, thank you. Y'all have a good day.
Thank you, Your Honor.
Thank you. Mr. Burbank, you've got Devin Byerly. Good morning. Morning, Ms. Mulkey. Good morning, sir. Are you Devin Keith Byerly? And Mr. Byerly has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800, on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Judge, obviously I will defer to, whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is
Right.
no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Byerly. So I know that he's entitled to a bond as
Well,
he is on deferred.
Maybe
but-
he is without certain findings, so that's why we're here. So just also for the record, Mr. Byerly, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at a other location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what, do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the board is.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be
So I
helpful?
received his case, I became his officer in February of last year.
Okay,
And since then, I have put him in ISF cognitive, I have put him in JCDI. Prior, he's done an MRT. He tells us that he understands that he has a drug problem, but then still continues to do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he would need a bond was so he could go work out of county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
yeah, I don't either.
Can I have?
You may, go
can I
ahead.
ask her a question? When did you place it on JCDI? Do you know the date of this time? When was you actually placed it? Was it 2019? When you placed it on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions. And we believe outpatient would be the best for him. He had spoken to me briefly as well that he had, some issues he wanted to talk through. He had some family issues he wanted to talk through. So we got him being in front of a counselor, him getting that drug treatment is what he needed. He agreed with us, that's what he needed. So we believe that outpatient program is the best option for him.
Did he go to JCDI?
He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI? or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program,
So it was the new offense that dropped him, it wasn't him not going?
as well as the drug use.
And was there another program too that you said?
He had done ISF, cognitive track.
And what is that?
It is, the interesting facility that we have, that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else, Mr. Burbank?
Mr. Barlow, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir. I did.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I believe I mentioned also to you that I would like to get into an outpatient program at Raquel West State Hospital, which will allow me to, I just told you that I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I normally work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am a longshoreman.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir, it is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I
you
work
would go to.
at, as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your payments.
Yes, ma'am.
You had a stroke last year?
Yes,
And you're still testing positive for drugs after having a stroke.
yes, ma'am.
Okay. All right.
Issues, that's not an excuse, but that's my daughter.
Do you have a place to stay?
Yes, I do.
And where is that?
Two was apartments, Mosaic Apartments is where I
Who
live.
stays with you?
No, I live by myself.
Who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister was playing Byerly, also my mother, Byerly, and uncle, Christopher Norris.
And how far away do they live?
Well, as far as my mother and my sister, they live in Houston. As far as a good friend of mine, she lives right there in Fort Austin, Martin Frazier.
Do you have any kids?
Yes, sir.
And where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, I got two kids here in Beaumont, one that I'm not allowed to see, and then also Tristan, who I just reconnected with Tristan, my 11-year-old.
Mr. Viola, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
Well, for one,
What guarantees?
I would accept that offer of the batch, and I would guarantee, I just want to get back to work. What I do, I don't go to work, you come home.
You do other things, because you've done other things.
Yes, I have.
So what's the guarantee that says you're not gonna do those other things when you're doing work and going home?
I just particular time offer my word, the past doesn't.
That's right.
Yes, and that's one I'll tell you, I see this as my last opportunity to keep everything that I have and that's.
One of the things is that you tested positive. What date was that, Your Honor? On
I don't know, Mr. Burbank. What date is it?
Now, I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that date?
Yes, I did.
And was there a date also of positive for cocaine? Was there?
Yes,
Yeah, there was. So those allegations are true, correct? If the court is not considering a bond,
needs help. He has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled, we're not sworn in, or, I mean, if he wants to plead to the motion, we can take care of that. With regard to the bond, the allegations, at least for that new offense on May 29th of this year, is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you, allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after. This is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation. Let's work with them. Let's work with them. Let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If, depending on what the plea is on the, excuse me, the new charge of possession, we can get with the lab, and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I mean, I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is. And
That's fine.
Maybe a question
I
on
think
that.
we can get that taken care of if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm going to go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Byerly, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, let me get this pulled up that way. I think I can do it. So, will he waive the formal reading of the motion?
Be well, Your Honor.
It's mine, Judge. I'm trying to turn it off.
Mr. Byerly, in 18-28800, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, and that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 18-29063, that's what I need, thanks. Correct. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, 3rd-degree felony, and that was a 10-year deferred probation. Is that also correct? Both of these motions allege that you violated your probation. Count 1 alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates. And is that true or not true? Count 3 alleges in each case that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged. So I'm going to put not true to the way that one is worded. Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count 5 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
Not true.
Count 6 alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true? Count 7 alleges that you were at a location other than your residence at approximately 3:19 a.m., May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that if we can get that expedited. All right, we'll see y'all back at sentencing. Yes, sir, thank you. Give me just a second.
Thought you had the motion.
Well, I had it up here and I had other stuff here. I had some of it. It's hard to have them both pulled up and. Okay, yes, ma'am. What was it, 2, 4, and 7? He pled 2, 4, and 7.
All but the new allegations.
Yeah.
Possessions of assault.
Got it.
Well, the 2 allegations of it. And then there was one in reference to JCDI.
Got it. 2, 4, and 7.
Wasn't-
Okay. All right, Brandon Dodd, Mr. Burbank. Good morning. Are you Brandon Dodd? And this is 242418. Mr. Dodd is charged with murder. And Mr. Burbank, what is the announcement?
We have been, as you know, I'm the second, or maybe third attorney, judge, second attorney on this, just retained. I'm just asking for one more reset. We're almost up to speed. There were some questions I've gone over and talked at length with Mr. Dodd and just requesting more time. There is a co-defendant, but that doesn't make no difference.
Okay.
No objection, Judge.
All right, and so what I'll do, yeah, it looks like you've just been on it a short amount of time. Mr. Dodd, I'm going to reset your case one more time so you and Mr. Burbank can make sure you're both up to speed on everything that he's got, negotiations, and then we'll see if we can get an announcement at that next court date. All right, you can go back with the bailiff. See, is Mr. Gertz? Yes, sir. Thank you. Mr. Kimler. Mr. LeBlanc, you've got Linton Arsenault. Did I pass my, I hate that I get those, it was one of those tickles that wasn't getting. I know, I've got water and it's just one of those that gets you. Yeah. Good morning, sir. Are you Linton Arsenault? And this is 242190. Mr. Arsenault is charged with failure to comply with sex offender registration requirements. Mr. LeBlanc, what is the announcement?
Judge, I've gone over everything with him, and we thought I need to talk to Mr. Honkpower regarding it, count off. I believe it'll be something that we'll have worked out.
You believe it'll be what?
It'll be something we have worked out, I think.
Okay. And Mr. Honkpower's out this week, but he'll be back next week, right?
Yes, Judge, and Mr. LeBlanc did come and get the media.
Okay.
For this case as well.
Good.
I just have not discussed the offer with him. I'm happy to
Sure.
do so.
So what I'm gonna do, Mr. Arsenault, is reset your case, one more time, and it'll be that last reset. That'll give Mr. LeBlanc time to talk to the district attorney's office, make sure whatever offers they have, any negotiation is complete, make sure you've seen everything they have, and then we'll get an announcement at the next court date. Okay? Thank you, sir. You can go back with the bailiff. Thank you, Mr. LeBlanc. I don't know. I mean, I'm not opposed just because he would have to do all of that. And I want the new case indicted and part of the deal, not just to go away.
Right.
You know what I mean? I think.
It shows the lab is already in progress, so we'll just stay the course. And
I mean,
see
that's
where it
clearly
gets
what he
us.
needs. So I'm not opposed to it, but he's gonna have to take some responsibility for all that.
Okay.
Yeah. Let's see, Mr. Matuska, you've got Xavier Garner. Good morning, are you Xavier Garner?
Yes, ma'am.
And Mr. Garner has 4 cases, and 230957, harassment by a person in a correctional facility, 242322, aggravated sexual assault of a child, 242323, and 2324, indecency with a child. And Mr. Matuska, what is the announcement?
Your Honor, I've been able to collect most of the discovery, still trying to get some of the digital media. I do expect this case to be placed on the trial docket. I just need to get the digital media.
Okay.
I've talked to Mr. Nichols about that, and that should be shortly.
We did speak, Your Honor, but I've been out the last few days, so I wasn't able to get that resolved for him this time around.
Okay.
I think it shouldn't be hard to get it for him, make sure he has everything.
Okay, so I'll do one more reset, and this will be the last reset. Y'all make sure you visit about all of that. Mr. Garner, what I have here is a pile of jail incident reports. So I want you to make sure you know that I know everything you're doing in court. And if this goes to trial, a jury will know everything that you're doing in our jail. Do you understand that?
Yes, ma'am.
You're fighting, you are talking back in an extremely ugly way to the correctional officers who are just there trying to do their job. That's their job. They're just going to work every day. They don't need to hear this crap from you every day. Every single day you're talking back, you're calling names, you're not following the rules. You want to do it your way. When you're in jail, you don't get to do it your way. And if you do continue to do it your way, you're going to end up with another harassment of a public servant in a correctional facility. You're going to end up with more time if you get found guilty because a jury's going to be mad because they're going to hear about all these things. So I want you to stop and I want you to understand, and I've been telling every one of you, how old are you?
22.
22 years old. It's all of you young kids out there acting like absolute heathens. So if you want your life to get better, you tell the rest of them, hey, I'm not going to get in trouble anymore. Y'all do what you're going to do. But running up on people, stealing their food, calling names, it's only going to get you in more trouble. All right?
Yes, ma'am.
Go back with the bailiff. And we reset Ms. Broussard for Mr. Nix, correct? Mr. Rennick, you have tire, did I see Mr. Rennick?
Yes,
Working on it.
Okay.
He's got something for them, but he's still.
Mr. Joel here? What about Mr. Vasquez, are you ready to announce on Veronica Randall?
Can we hold on that, Your Honor?
Sure. Okay. And what about Mr. West? Mr. Rojas, are you ready on Lawrence Jackson?
I don't think we need him out. Ask for a reset on him. He wants to look at the videos on that new DWI.
Okay. And you've already got them? You just need to go out there and visit?
Yeah.
Okay. We'll just, on Lawrence Jackson, we're gonna reset Lawrence Jackson, for you to go show him those videos, and we'll get an announcement at the next one. Thank you. Mr. Parker, you have Cortland Pender.
I don't know, well, I don't know if we need him, Judge. I think Mr. Coleman's gonna confirm that, there's 3 cases in the motion that have been, my client claims they've been dismissed, and I think if we can reset 1 week. to
My
confirm that.
understanding is that they're out of Dallas County doing so sometime.
Okay.
It's a week from now.
Let's do,
Oh, yeah, of course.
do you wanna, how are we next week on? I don't know, the next week maybe just as, all right, let's just do 1 week on Cortland Pender. And then you've got Esker Boykin, Mr. Parker?
We have a clue, right?
Okay.
Well,
Oh, that goes in that other file I was, okay. Did we already do something on this? And then
He was evaluated. We started to, and we chose to have him evaluated.
okay. Good morning. Are you Esker Boykin Jr.? And this is 250351. I'm going to take judicial notice of the court's file. Mr. Boykin was examined by Dr. Krapon for competency to stand trial. I received that report dated May 21st of 2025. The finding in that report is that Mr. Boykin is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Mr. Coleman?
Not from the state judge.
All right, then at this time, I am going to find that Mr. Boykin is competent to stand trial. Mr. Parker, will he waive the formal reading of the indictment?
He will, Your Honor, and just for the court record, please do a lesser included.
Thank you, I'll do that. All right, so Mr. Boykin, in cause number 25, DCCR 0351, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that is from March 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind. Do you understand?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Did you have something? I'm sorry. All right, Mr. Boykin, I'm going to find that you entered your plea of guilty freely and voluntarily. I find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Veronica Randall, Mr. Vasquez, Ms. Malfino.
Good morning, ma'am.
Good morning.
Thank you for smiling. Good morning.
Good morning, ma'am. You're Veronica Randall. And Ms. Randall has two cases, 250246 and 0247. Both are theft of property with previous convictions. And Mr. Vasquez, what is the announcement?
Judge, could we ask for a short reset? I need to, Ms. Morfino's made a reasonable offer, but I need to do some research in Ms. Randall's case.
All right, and
Judge, I think this is Mr. Vasquez's first setting on this. Previous
I
setting,
see
you
that.
asked me to kind of map the indictment. It's so many priors that it almost makes you cross-eyed.
yes,
I think we just have a friendly disagreement on what level it is. The offer as I have made for 4 years, TDC would be valid if it was either a third or a second. Mr. Vasquez's position is that it's a state jail. I will go back and look at it again. That is not my position. I will have another set of eyes on it, because like I said, it's so much, it gets tangled up, but
And Your Honor,
regardless, I think it's at the very least a third, if not a second.
thank
okay.
you, Ms. Morfino, for your explanation. I'm sure I'll be in agreement, Your Honor. I'm just not certain right now,
Okay,
and I'm supposed to know these things.
that's okay. So what I'm gonna do is one more reset. This will be the last one. Y'all take a look at all of it and all the priors and get that worked out. And then we'll get an announcement at the next court date. Either it's gonna get worked out with the plea or it's gonna go in the trial docket. So Ms. Randall, I want you to know that I receive jail incident reports. So everything that happens out at the jail, I get a report of. The assistant district attorney gets it, your attorney gets it. If you want me to accept any plea agreement later, this behavior needs to change. If you go in front of a jury, they're gonna see these things. So you've got to follow the rules. If you want any benefit from any of us or a jury, you've got to show us that you can follow the rules and not continue what you've been doing in that jail. Do you understand? You're too old for this behavior, right? A lot of times I'm having this conversation with my 18, 19, 20, 21-year-old boys. That's who's acting up in the jail, not you. All right? So stop this, because everybody's going to know what you're doing. All right? Okay, we'll see you at the next court date. You can go back with the bailiff.
2 weeks.
Thank you, Your Honor.
2 weeks, okay? It just popped up on my phone.
Awesome. Good for him.
Sorry, I don't.
Philip,
2 weeks. Oh, here. Sorry.
I'll just tell him.
Thank you.
It's like you got pleading on two, correct? Thank you. Oh, that's what I spent my afternoon doing yesterday, was reading jail reports. I spent more time on jail reports than I did PSIs.
They're more voluminous.
Same names I keep saying. Let's see, so we are going on the MTRP in one new case. Let's go with this new case 25. Good morning, are you Jacqueline Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions, just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you? Okay. Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not going to let you guys negotiate. That I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 2137857,
Your Honor, it's a second amended, just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13, 13 being the offense he's already pled to.
okay, let me look at it. Thank you. I got it, thank you. So I have a second amended motion to revoke your community supervision. So you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And
Oh, it was
count 20
run.
reads motor vehicle, that's incorrect, Judge. It's evading on foot
Okay.
with priors.
Okay, gotcha. So this shows that you were placed on probation August 29th of 2022 for evading with a vehicle. And that was a 10-year sentence in prison that was probated for 5 years. Is that correct? And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true? What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending. The misdemeanor.
The failure ID is still pending next door.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
I will double check and see if there's, I didn't see anything else that like filed or pending. At this point, I'll check and see if there's a lab report pending, but I don't think that's been filed.
Okay. Let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation. One of the allegations, so I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery. You think community service is slavery? Do you think that?
No.
It's the same, I'm not taking 5 on the MCRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more, but that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different, but I'm not gonna do that. Let's see, so I already did that one. Okay, great. There goes something else probably going out to everybody. Now my computer's stuck. Are they? It just, yeah, it's not letting me do anything. Oh, it just let me do something. But I thought I sent this one to you. Let me double check why it didn't go. So that one's done. Did I print out the certification on 0309? Do you see it? Here, I'm printing it out now again, just in case so I can close it. Because I did already do that one, so. All right, so.
Today's courtroom wasn't just about sentencing, it was about second chances, accountability, and the difficult choices judges face every single day. Some defendants were given more time to prove they could change. Others were reminded that excuses eventually run out, and every broken promise makes the next decision even harder. One thing stood out throughout these hearings: the court wasn't looking for perfect people, it was looking for people willing to take responsibility and follow through with their actions. Whether it was missing court orders, violating probation, struggling with addiction, or battling mental illness, every case showed how one decision can completely change the course of a life. But here's the question that every viewer should think about: how many opportunities should someone get before the justice system decides enough is enough? Let us know your thoughts in the comments below. And if you enjoy real courtroom breakdowns, legal analysis, and the most compelling moments from the justice system, make sure to subscribe, because the next case may be even more unbelievable than this one.